Hello, everyone. I've been told that it is time for us to get down to business, so I'd like to start by introducing myself. My name is Robert Lawler. I've been an IP lawyer for, I don't know, like 15-ish years now, mostly focusing on patent and copyright with some trademark expertise as well. So it's really a system that has multiple legs. You can think of it as a three-legged stool, and they all help support interlocking ideas of protecting overall intellectual property. So, I mean, we can start with a little poll of the room here. Anybody ever gotten a patent? Hey, good. Okay. Anybody ever actually registered for a copyright? Excellent. Trademark holders? Okay, so we have some folks out there that have interacted with the system somewhat, but there's a bunch of people in here that haven't at all. So I'll start with a sort of an overview of what the three, you can call it four, basic types of IP really are. There's patents, and those are going to cover physical inventions and methods of doing something. So if everybody remember the game Mousetrap? The little device on the board, that little Rube Goldberg contraption, that is the type of game element that you could actually patent. Then, of course, there's copyright, which covers your creative, artistic expression, whether it's music, written word, audio-visual, paintings, sculptures, architectural designs. There's a really broad amount of creative expression that can be covered by copyright. And then there is trademark, which is identifying who is making or selling something. So all three of those are interrelated in a lot of their basic concepts and the way the law works, but they cover discrete areas of things you want to protect. There's trade secrets, probably not too relevant to most people in this room, but I'm always willing to discuss that too if anybody's interested. A great way to think about IP and the way they interact is you whip out your mobile phone. The patents are going to cover the physical device, things like the battery chemistry, the LCD screen. Copyright is going to cover things like the user manual, the operating system. And of course, the trademark is going to be who's selling it. Is it an iPhone, your Apple product? Is it a Nokia? Is it an Android? So even in one object like that, you can have a lot of different ways to protect specific portions of the intellectual property that all is rolled into that one simple device, or complicated device. And for example, the patents can be very discrete portions of that. One could patent a particular type of battery chemistry, lithium ion, for example. You could cover the fractal nature of the antenna. That's pretty cool. But just building a phone doesn't mean that you're going to necessarily use a particular type of battery, doesn't mean you're going to use a particular type of antenna design. So when you think about what are the protectable elements in anything you're designing, you often really need to drill down to a particular element. Is that something you have invented? Is it something you have created? Is it something that you are using as the source identifier for your game? So while I want to keep this at sort of a general, higher level, for the most part, the patent realm is not going to be of as much interest to the folks in this room as copyright and trademark. So I'm going to focus primarily on those, but certainly if anybody has any questions, feel free to kick up your hand and let me know if there's additional detail on something that I can help you with. More than happy to do that. So let's step over to starting to talk about copyright and what that really encompasses at the conceptual level, and then some more specifics. The biggest thing to remember about copyrights, if you want to have one takeaway from this, is that there are ideas and there are expressions of ideas. This is something that can be a hard thing to wrap your head around conceptually. It is the focus of endless hours of debate in law school. Fun debate, but sometimes a little frustrating trying to really figure out what that line is. But in terms of expression, anytime you write something, you create, you draw, you sculpt, that is the physical expression you're talking about. A rule set for a board game is a particular expression of a more broader and general idea. Think about Monopoly. You could conceptualize that as you roll 2 dice and you go around the board. Now, you can't copyright that idea. You can copyright the particular rules that Parker Brothers publishes. You can copyright the Mr. Monopoly character. You can copyright the exact layout of the board itself. But you can't really copyright the idea of Monopoly. So when you're thinking about something anybody in this room is going to create and hopefully market and hopefully publish and hopefully sell, you want to prevent somebody from ripping you off, copying you blatantly. But if somebody comes up with a similar game with a generally similar mechanic, that is not something that you're going to be able to completely shut somebody else down from doing. So yeah, there we go. Idea versus expression. It's fun. It can be frustrating. Are there any particulars about copywriting a board game that would be of interest to folks in this room? Go.
So one of my games has 11 cards, which all have graphic images that we've created.
Mm-hmm.
So my understanding is so I can copyright that, and then I can submit for copyright. So you don't have to submit to actually use the copyright, right? You can establish copyright without submitting it, but I would submit that as a collection, is my understanding, instead of each individual card element, if I were to submit it to Library of Congress.
Correct. The registration process, and we can get into that a little bit later, does involve paying it's a pretty modest fee. It's like, yeah, it's cheap, and for the most part, pretty much everybody in this room could do it themselves. It's not complicated. There's an online electronic form that the Copyright Office provides. But yes, what you would be seeking protection for is the graphical art elements that are on the card. And you could do those as a set of 11. That should be no problem. Again, getting back to the idea part, you can't copyright a game deck that has 11 cards in it. You can't copyright, I don't know what the specific mechanic is, but somebody could come up with a similar mechanic game, and if they use their own art and had their own characters and own graphic design on that, and yet had a similar game play, a style of play, that would be fine as far as copyright law goes. So again, keeping with the sort of broad theme of the 50,000-foot view of what the various types of IP get and help you protect, so we can take a step over to trademark. And the fundamental right that you have as a trademark holder is to prevent somebody in a similar type of business from confusing a customer about who is selling a product or service. The flip side of that is that somebody can use the exact same trademark in a lot of cases if they are in a different line of work or different business. Classic examples are United Airlines versus United Van Lines. Nobody confuses the shuttle people around in a giant tin can in the sky versus the movers. Hopefully, nobody is going to get confused by a Dove chocolate bar versus a Dove soap bar. And if you do, you'll figure it out pretty quickly. So, there, the standard is identifying a source, a producer, or a provider of services. So, this gentleman here had asked about a OK symbol from somebody that is in a completely different line of work. Yeah, an apron company. Really not too likely to confuse the average customer who goes, who goes on Amazon and is looking for a board game with a OK symbol. If an apron comes up, they're not going to buy an apron thinking it's a board game. Hopefully. So there again, the fundamental role of a trademark is to help a customer figure out who is selling them something, where it comes from, who's providing a service, and really that's all that you get from a trademark. They are obviously highly valuable. In terms of duration, trademark is the one piece of IP that has a theoretically indefinite lifetime. As long as you are selling or producing a good or providing a service and you keep your registration current, it can go for 500 or 1,000 years in theory, which contrasts to patents with the relatively short 20-year lifetime, and then copyright's sort of all over the place because there have been the various extensions, but that is life of the author plus 70 years typically, currently, or 95 years for a corporate work, for example, which is still a really long time. I don't think that I'm too worried about any copyrights in something that I've created expiring before I shuffle off this mortal coil. But it's obviously pretty important for folks like Disney to keep their copyrights on the big mouse guy for as long as possible. I'll touch on patents briefly. Like I said, it's probably not a key way for folks in the game industry to protect something they've created, but as I alluded to earlier with the mousetrap example, there are some circumstances where it can be useful. What you get from a patent is the ability to prevent somebody else from making the thing you have patented and claimed. If you think about a device, this fine device here, if there is a patent on, say, that microphone configuration, a person could produce a different type of portable recorder that, say, had the mics going this way instead of this way, if the configuration of that crossed mic was the subject of a patent claim. But you, again, can't, in general, exclude somebody from making a portable recording device because that would be too broad and the patent office would never give you a patent on that. So one thing that I spent a number of years working on was DNA sequencing. And it provides a great example of the different ways that you can use a patent to cover a single technology. You can patent the machine that does the sequencing. You can patent the individual chemicals, the chemical compositions that actually do the chemistry side of it within the machine. And you can you can get what's called a method patent, where you claim a method of doing something. So you can think of that as like a claim to a process. Utility patents are probably off limits for most game design. If you come up with a truly novel and unique game mechanic, it is possible to get a utility patent on that. But it's often going to be an uphill battle, and there's so much prior art out there that it's probably not the direction I would recommend most people go. What you can do in the patent realm itself is let's say you have a new and unique board, like physical board game design, that would be amenable to a design patent where you're claiming the ornamental features, the aesthetic features of your game design. That actually works sort of hand in hand with copyright design. But if you think about, say, the configuration of the board in Small World, where you have a specific layout and the shape of the board and the way the individual races come onto the board, you couldn't really duplicate the game mechanic of Small World in an identical fashion if a person has a design patent on that aesthetic layout. You could come up with something that would be close, but not identical. So that's going to provide some protection from somebody really trying to make a clone of a game you've designed. But the further afield that they get from an actual cloning of a game, the less and less ability you will have to stop them. So there's going to be a trade-off in there. And that should be something that, if you're thinking about trying to protect a game with a design patent, that would be something to consult probably with a lawyer on. Time frame on a design patent is about 14 years from the time of application. So it does give you a pretty good window to establish yourself in the market and exclude competition with either a design patent or a combination of design, patent, and copyright protection. So let's see. So we've discussed that it's a patent really is a property right that gives you the ability to prevent somebody else from doing something. One other key thing to remember is that it's very territorially focused. If you get a patent in the U.S., it really only applies to making, using, selling, offering for sale in the United States. A person literally could take your patent and sell it in your patented object and sell it in China or Japan or the European Union, unless you go through the considerable additional expense of filing in a wide variety of countries. That tends to be worth it for pharmaceutical giants that have large budgets and profits that can be in the hundreds of millions of dollars for a particular drug. It is probably going to be less worth it for people in the game design industry. The returns just aren't going to be there. It's something you can always try to balance, but my expectation would be that it would not be worth it for most of the people in this room. Does that all make sense so far? Any questions before I go on? Go ahead.
Do you have an opinion about the Wizards of the Coast and the Magic the Gathering tap patent?
Let's see. The specific question was, do I have an opinion on Magic the Gathering and Wizards of the Coast tap patent? I do not. It's not something I've specifically looked into. Could you give me a 30-second synopsis of what the claim is?
Well, what I know about it is that they patented in the game. There's a mechanic when you use the card, you turn it sideways, and you call that card tapped. And they patented that. So I've read on the internet. So it must be
Well, yeah, everything you read on the internet is, of course, true. But no, I'd be interested in taking a look at that. I'll probably go home and Google it. Oh, well, okay. Thanks.
4 years ago, or 3 years ago.
Do you know when it was filed? Did they let it expire, or did it hit its 20 years?
It hit its 20 years.
Okay.
The game's over 20 years old.
Yeah, that totally makes sense.
I don't believe it was the actual tapping of the card. It was the word tapping a card.
Now they have trademarked the symbol that they use for tapping.
Yeah.
And so now that is a trademark, which is a different kind of intellectual.
Sure, and even trademarking it is a little iffy, because if it's within the rule set, it's not something that's on the exterior packaging that is used to literally identify where the game is coming from. Wizards of the Coast, Magic the Gathering, eminently trademarkable names. Something that's in the rules that is a symbol to turn it. Unless you are putting that same symbol on the outside of your packaging, a customer is not going to see that. A customer is not going to be making the association that that symbol means, oh, this game is coming from Wizards of the Coast. So that's it's a good example of trying to separate out what the IP is useful for, and in this case, it doesn't seem to me, based on what JT and you have said, that tap symbol is really associated much with who is making the game. Now, I'm sure Wizards of the Coast has a different view, and I'm sure that if you use an identical symbol in your instructions, they will send you a nastygram. Whether they would be able to follow through with it and win in a court of law is probably kind of iffy. They probably have a large enough budget that they can make your life very inconvenient and expensive, and that's probably what they're going for more than actually having a really solid, non-contestable legal case.
I can say as a player of the game, I do know that symbol.
Okay.
Immediately. So if you were to say, if Wizards were to say, well, this is what our customers recognize, they would not be lying at all.
Sure.
And they would recognize this as a Magic product, totally.
Yeah, they will go after you. I worked at
Oh, they
Wizards.
will.
I worked at Wizards of the Coast for 15 years, and I saw many people stepped up.
Yeah. Yeah.
They'll go after you.
Yep. Yes. There's always room for a larger and wealthier company to.
Well, and they're owned by Hasbro, right? Therefore, they're a really big company. Their
Yep.
lawyers have deep pockets.
Yep. So right, and right there, we're touching on something that is almost outside of the the reality of the strength of your legal case and just getting into raw power and money. And unfortunately, you can have the best legal case in the world, and it's still not worth fighting because you'll be ground into bankruptcy before you win, and that doesn't really benefit anyone. So yes, there's always in any of this the caveat that you need to pick your battles, and sometimes it's like, okay, I'm just not going to use that sideways rotation symbol, and I'll come up with something else to describe turn the card sideways to show that it has been removed from play. But even as large and well off as they are, they can't prevent a game designer from saying in their rule set, when the card is removed from play, rotate it 90 degrees. For pretty obvious reasons. That is a very basic way to actually physically implement a game that is not protectable under any of patent or copyright or trademark. And it's obviously not a trade secret.
Look up that whole patent.
I will.
Exactly what they patented.
Well,
Somehow. They made a lot of money off of Yu-Gi-Oh! and other games that came out in that era of the patent by taking a royalty in lieu of settling in court. They would
right.
say, well, Yu-Gi-Oh! You can make your game where you turn your card sideways, and we'll take a percentage. And I know that they made millions off of those games. So.
Yep. But right there, you may be getting into the realm of the Yu-Gi-Oh! Developers saying, okay, we can pay 5%, or we can spend $5 million litigating it.
Are you saying it was more like they made that money via extortion?
Extortion is not the exactly correct word, but it really captures the spirit of it. Yes. Yes.
So, legally speaking, what is a game? I work at a university with students who design video games and board games, and I've worked with the university's legal department for 3 years, and they've given It's not an invention, it's not a discovery. They don't know how to provide protection for the students' creations for a game.
Okay.
Is there one term or one category that it falls under collectively?
So the protectable elements, and this sort of gets into, well, right here we have, can I patent a game? The protectable elements in a game are generally not, with the noted patent on rotating a card there, are generally not fairly common mechanic elements. Like I said, there is plenty of prior art out there on roll 2 dice and move around a board. You're not ever going to get a patent on that. And at the other end, if you have the mousetrap example where you have a very specific device that is incorporated into the game, that device can be protectable. I believe you just mentioned that some of the students are developing video games?
Board games and video games, yeah.
Okay. In the video game realm, the source code is copyrightable. The sprites, the character design, the graphical look and feel of a particular game can be copyrighted. But the more general idea of a side-scrolling shooter, no. In the realm of design, you can get that 14-year design patent for a specific novel layout of a board.
You have to pursue each one individually. A game is not an entity unto itself.
A game is not an entity unto itself. A game is, going back to that 50,000-foot view level, a game is sort of like a cell phone. You can't patent the idea of a cell phone. You can patent a new screen, a new battery chemistry, a new, maybe even a new layout of the buttons if they've got like curves on them that are different. Apple has done things like you get design patents on the very specific features of rounded corners on a cell phone. In some ways it's absurdly specific, and in some ways it is only preventing somebody from making an exact copy of the look and feel of an iPhone. But you have to drill down into the specific elements of what you're trying to protect and look at it from that perspective. So, if a set of students, did come up with a novel character that is present in the video game, you could copyright that character, much the same way Sherlock Holmes is as an entity is copyrighted.
Could you copyright multiple characters as a set? Just like in the example I said with the cards, where like the imagery on all the cards, I can do that as like a collection in the copyright versus individually. Like use Mario for example, Mario, Luigi, the princess, etc. That's a collection of characters that are in Mario World.
So getting back to the sort of idea versus expression dichotomy, I would, and it very quickly gets nebulous in there, but when you talk about copywriting something, you are actually copywriting specific representations of them. The legal buzzword is it is something that is fixed in a tangible medium of expression. So you can't copyright the idea of Mario. You can copyright a particular drawing or representation of him. And from that, if somebody redraws it, obviously copying the idea of Mario, you'd be getting into a derivative work, a copy of him, versus the idea of Mario or the idea of a set of characters. So for the copyright aspects, you need to focus down, and the protectable elements there are the representations of Mario rather than Mario and Friends as a concept. Now, I would strongly argue that Mario would also be very protectable by trademarks. He is a widely recognized character. Everybody who sees that character knows that it is, derived from Nintendo. There's a strong association with Mario. Oh, it's a Nintendo product. So that would be an excellent example of using more than one IP regime to protect that character. But as far as protecting the entire group with a single registration, for something that valuable, I would probably register each of them individually, which wouldn't be necessarily the case with just a set of 11 related cards. Yes?
I was going to ask about that interrelated, like multiple registration type of thing. Like if I could, in theory, just collapse all of the content in my game into one big Word doc or something like that and be like, here's the content that I would like to copyright. Is that a valid way to do that, or is it easier to do it piecemeal and kind of say, this is a specific thing, this is what I want to copyright? I mean, I can take out the images and stuff as a separate discussion, but is there a benefit either direction for like splicing it out into individual things versus having it all in one?
In the example you give of having a single document that has the entire description of the game, so the rule sets, the characters, the cards, doing it as one document would be fine. Even if a person copies, let's assume that some competitor out there blatantly copies, cut and pastes, say 1/3 of your game, and doesn't copy the other 2/3. Having it all in one doc, they would still have been copying verbatim stuff that you have copyrighted, and whether it's piecemeal or all of it, they are still violating your copyright. So there's not really a big downside to doing one registration for say an entire game. Let's see, I think I saw another hand here.
Yeah, just specifically on the trademark.
Mm-hmm.
Can you break it down? What do I have? I've got a game company. I need to trademark that. I've got the name of the game. I need to trademark that. I've got a logo on my of my company. I've got a logo on the game. Do I do all these separately, or? For trademark, yes, you would be. It would be probably advisable to trademark the name of your company. If you have a logo, that is eminently protectable. Perhaps a good generic example here is Coca-Cola. Coca-Cola has the name Coca-Cola. They've trademarked that. They have also trademarked things like the shape of the Coke bottle itself. And those are separate and distinct concepts that company from Atlanta wants to protect individually from each other. So they don't want somebody, putting their own soda in a bottle that is shaped like the classic Coke bottle. And they also don't want somebody selling soda-like products under the name Coca-Cola. So yeah, that would be a great example of two different and distinct registrations. But it does come back to what you want to protect. If you have a game and you want to associate your company with as the provider of that game, I would probably end up recommending a trademark on both the company and the name of the game. Yes, in the back.
Is there any point at which you are protected without going through the process?
Well, yes.
Such as, I can demonstrate that I exist. I existed 5 years ago. This game existed 5 years ago, et cetera, et cetera.
Right. In the different regimes of copyright and trademark, there are some protections that you get without going through any formal process. The easiest one is copyright. The moment you create a artistic work and you fix it in that tangible medium of expression, you write it down, or you sculpt it, or you paint it, you have a copyright from basically the moment of creation. What the registration gets you, and again, it's quick and relatively cheap, and is well worth doing for a piece of IP that you want to protect. What a copyright registration actually gets you is there's an evidentiary function. You have told the government, as of this date, this existed, and that can actually be pretty useful because it gets you over the hurdle of proving that 5 years ago I had this, or was it 6, or was it 4? The other thing that the registration gets you is useful if you are actually suing somebody. There are provisions for statutory damages, like $750 for every copy of the copyrighted product that is copied, and the possibility of attorney's fees. But those side benefits, while handy, are not required in order to get the copyright itself. Going back to trademark, there are common law trademarks that are typically acquired through use. The protection is more limited. It's only going to protect you in the areas where you have been selling. So for example, if one opens up a burger restaurant in 1960 or 1950, and you happen to call it McDonald's, and then 20 years later, the McDonald's franchise starts, and they go and register a trademark, you might be able to prove I was using McDonald's first, so I'm still allowed to call my restaurant McDonald's, but you would only be able to do it in the town or location or the state where you had it originally. It wouldn't be nationwide in scope. So one of the big advantages of the trademark registration process is that you get a national scope, and again, some more presumptions of validity and presumptions of timing and presumptions of notice to other people that might also want to call their restaurant McDonald's. Yes?
So that actual case exists with Burger King.
It does.
In Mattoon, Illinois, the guy owns the right to Burger King before Burger King. But my question is, it feels like that law was like written so long ago. Now we're in e-commerce. I don't have a retail storefront where I sell my game. Everything's done e-commerce. I do everything online. So where do I operate?
You know, I'm not specifically aware of cases that address what the national scope of a unregistered trademark like that are. Fun question. Oh, hey!
I went to file it and someone else was filing around the same time, and I've been using TM. And because I had sold my for consulting services, I had sold them in the state they were located in. Because the client was in that state, it was California.
Okay.
I was able to make the preemptive claim, and they backed off, and I got the trademark. So at least for my specific example, it was based on the state of purchase.
Okay. Yeah. So, in the case where you have multiple people that are in the application process, the big evidentiary issue there is establishing that first use. And it sounds like you were able to establish that you used it first, and that since neither one of you had a registered trademark, neither one of you had the presumption of national validity and national scope. But that is exactly why just going ahead and applying is so useful, because it transfers that one state or one location or one area of use into instantaneously covering the entire United States. And it throws that line, it throws that flag down in the sand and gets you that level of coverage.
I'm kind of hearing you say that even if you get any of these protections and pay the money to file them, if you actually want them to stand, you need money and effort to protect, to go forward and protect them. So it seems like I'm hearing you say there's no point in investing in this if you're not going to be willing and ready to spend money on backing it up if something happens. And also if this is something that you are not going to be making a lot of money on, the amount of investment can be ridiculous for the legal backing. If this is not your livelihood, it's probably not as worth protecting.
Or registering, if you do a TM versus a register?
Right, just putting a TM by something you're using is a indicator to the public that you are considering it as a source identifier, as a trademark, without going through that process. But it does mean that somebody else could go ahead and register it, and they might get the ability to use it nationwide, and you wouldn't. But as far as cost goes, copyright registration is pretty darn cheap, and you can do it yourself pretty easily. A trademark registration, is a little more complicated, but can be done by yourself at the USPTO for hundreds of dollars. So if it's not worth a couple $100 based on your sales, then it's not worth it. But it's also not terribly expensive.
If you file incorrectly, you don't get a refund. They don't give you your money back or a chance to amend. That's what I read online at least.
You rarely get your money back, but the application process is also not that complicated. Copyright registration is something that I would encourage everybody here to just go check out copyright.gov and familiarize yourself with that process, because it actually is pretty straightforward. A trademark registration can be acquired even with an hour or two of lawyer's time for less than $1,000. It is not terribly expensive. What is terribly expensive is starting to patent stuff. There you're more in the a couple thousand and up territory. Yes?
Part of the question, I think, is what about those legal fees when you actually want to go forward and enforce it? You find somebody that's violating something that's registered, and you've done it all properly, but that can be addressed. Certainly if you went against Wizards of the Coast, you can get grounded and referred pretty quickly. But there are other levels of violators, perhaps, and if you could talk a little bit about how expensive it is to litigate it after.
Well, one of the aspects there is what exactly is being litigated. I have done patent litigation relating to things like the batteries that go in current generation power tools, where there is literally hundreds of millions of dollars on the table. And then at the other end, writing a letter saying, hey, we have this trademark. You shouldn't do something that is going to confuse customers. And you send them a letter, and then you call them up, and you have a nice conversation with the person on the other end of the phone line, and they go, okay, we'll stop. We'll do something else.
Gives you more weight on a cease and desist.
Having the registration, particularly the trademark registration, is very valuable for. No, we've actually already filed this with the government. It's real. We're not just yanking your chain. In the copyright realm, if you have a registered copyright, you have the ability to hit people you know, and this assumes that they are blatantly ripping you off, that they are actively copying something. Like, so let's say I went and started selling cards with Mario on them. I would fully expect Nintendo to give me a call, and then they would be able to ask a court for $750 for every Mario branded object that I sold, and attorney's fees. So I would be on the hook for Nintendo's attorney's fees rather than Nintendo being required to pay it. So that's one of the areas where having a registration can be very advantageous, and mean that the person that is ripping you off is the one that is ultimately going to be on the hook for some of the legal fees. So that can be a very powerful reason to go ahead and spend that $100 or $200 on registering your copyright in the first place.
But does that require you to win? And can they get it so tied up that you'll never win? You'll run out of money before you win?
Well, depends on how deep your pockets are. Yeah, that's not the sort of thing that's ever amenable to an easy answer. Yeah.
Yes.
Most people will get it, and especially if you call them then after they get it, most people just back off.
Yeah.
Imagine getting
Yeah,
one
I've
for
had that
like-
experience where it was like, I got a lawyer. Yeah, but it depends on who it is. If it's just some schmo, yes. But if, like he said, it's a Wizard of the Coast, they know what they can do, so.
But you also have the court of public opinion. I mean, that's part of, if you want to fight dirty, like big corporation.
Well, if people
Yeah.
find out about it.
You do an arbiters.
Yeah. So, a lot of it is going to come down to, how valuable the property you're trying to protect is, the extent to which your competition is ripping you off. If they are, copying your rule set word for word, or they have, or at the other end, they too have a game that involves rolling 2 dice and rolling around a board. If I were to copy something blatantly, that's easy to prove, and I know that I would be on the hook for that sooner or later. So you can always tie stuff up in court for some period of time, but ultimately, a decision is going to come down, and if you are on the wrong side of it, you are going to be liable. So merely having, even Wizard of the Coast level funds backing you up doesn't mean you will always win. If they were to blatantly copy something, they'd be on the hook too eventually. Yes.
So I have a question about use of parody, kind of how that works out. I mean, I know that's kind of something you see a lot in board games, is parodies of things. I'm just kind of wondering where that falls under. So, like for example, I'm working on a game that's about making movies, so the players are trying to win Oscar awards. So I mean, don't want to get sued by the Academy or anything. So. But I was just wondering, how far does that kind of extend? What does that get you? What falls under parody?
Okay, so I don't have specific stuff on parody in here. It's a fascinating area. It generally has to be, doesn't have to be. It is stronger if you are using something in a new and creative context. Does that make sense? You can't just blatantly copy something and call it, oh, it's a parody, and get away with it. But in the example you give, where where players are trying to get an Oscar, I'm sure that the Oscars have a trademark on that name, but no one is likely to confuse your board game with the presentation of statuettes in a Hollywood ceremony. So, since you're already operating in arguably very different classes of business, the fact that they have an Oscar trademark might not even be relevant. One of the two gentlemen in the back.
Yeah, so this goes to the question I have too, but it's also, he can't use Oscars in promotional material, right?
Yeah.
The other question I wanted to ask is very similar, which is about the right to publicity.
Okay.
For individuals. So, like, if he's promoting, right, he's got, it's Oscar, he can't say, you know, win an Oscar in this game, obviously, because then they can come after, cross promotion. What, if you have a personage in your game, so I have a game and Ronald Reagan is a character in the game that you should be able to play. However, what are the limits that I have in promotion and or representation around that actual person?
Okay, right of publicity is something that is not actually recognized at the federal level. It is a mishmash of individual state restrictions, so it quickly gets annoyingly complicated.
This is what I discovered. My basic premise was I can use him as long as I don't promote the fact that I'm using him in any way in the market.
Right. So in the case of Ronald Reagan, he's also a historical political figure. You're going to have more latitude to use him in that context than, say, Elvis. If only because the people of the Presley estate are very litigious about that. Right of publicity is a weird one, precisely because there's so much variability from state to state. So it really is kind of hard to give you a concrete answer on that.
You can't flat out use his image in your game, though.
Who, Elvis?
Ronald Reagan.
Well, you could certainly draw your own image of Reagan. You could take
They did that in the Illuminati card game.
Yeah, you could take a public domain image of Reagan. Say anything that a government photographer ever took is automatically exempt from copyright. So there are plenty of ways in which you could actually use an image of Reagan. I think I would not put it on the cover of your game necessarily, but if you were having a card game of the U.S. presidents, it is not only I think fair use, but it is pretty much required that you be able to use the name and likeness of all 45 of them. The other gentleman in back.
Yeah, I actually had a somewhat related question about the right of celebrity. You're seeing on Kickstarter right now some of these like action heroes of the 1980s games and stuff. If you're interested in using caricatures of, celebrities, obviously if you're flattering to them, they're going to be really happy and not care. But if you're not so flattering, then you could draw. How do you end up advising along those lines if the laws are different in every single state where you'd ultimately be selling?
Yeah, well, that is unfortunately one of the downsides to having a 50-state system. It really does get annoyingly specific very quickly. You may end up running into things like is it fair use when you're looking at a question of is their image copyrighted, or have you created your own? If you do your own drawing of it, you're not using a existing copywritten image. But yeah, the right of publicity and the right of using somebody's likeness is a thing where you really are going to have to look at the most restrictive regimes that are out there, and then try to conform to say the state of California's rules, because that's a lot more restrictive than the, I believe, completely non-existent right of publicity in Wyoming. So I guess you could sell your game only in Wyoming, but that's not going to be as lucrative a market. Yes?
So I'm going to go way back to when we were talking about registration for both trademark and I, for example, don't register my copyright or trademark right away, can I do so after the fact? If so, does my new registration cover time that I didn't before I had my registration?
Yes. What you, with the timing is probably a little more important for trademark than it is for copyright, because as I said earlier, the copyright springs into existence the moment you make that drawing on the paper, the moment you write the source code, whatever it is. But for trademark, what you're really trying to establish is the date of first use. And there's a specific spot on the trademark application where you write down your date of first use. And it can either be in the past, or it can be, there's an intent to use application, or part of the application where you can say, I'm going to start selling a product in the next 6 months, but I want to get my trademark for it now. We very often see this with large companies, like Apple does this all the time. When they come out with a new name for their operating system, they'll file an ITU form for that before they make it public, so that nobody can come in and scoop them and say, oh, I just happened to trademark that 2 days ago. So yeah, it's the date of first use for trademark, and you don't get the benefit of the public notice, but if you have two competing people who are trying to trademark the same item, it's the date of first use that is very often controlling, as I believe one of our attendees here already experienced.
We got time for probably one more.
Okay, how about you? You've had your hand up for a while. Sorry.
If you have, let's say, a Wizards of the Coast, and you have a figurine that they make,
Mm-hmm.
and you buy it from them, can you put that in your game and put that picture on your box?
I would be very, very hesitant to put the picture on the box. Once you purchase an object, the broad answer is that object is yours. You can resell it. You can smash it with a hammer. You can do anything you want with it. You can't make more of them, and I would be very hesitant to advertise. Use that figure as an advertising hook for anything like on your packaging. I don't see, broadly conceptually speaking, I don't see a huge problem with buying 10 figurines, putting them in a box, and reselling them. That would be no different than selling a collection of Star Wars toys. You just can't make your own new Star Wars toys.
Even if you put the supplied by Wizards of the Coast.
But like I said, if you are buying it from them, you have the ability to resell that particular figurine. What you don't have is the ability to create more of them. Have time for one more?
Sure.
Okay.
So you see first use of trademark. So if I sent an image to a graphic designer of my logo, but it didn't have a TM on it, right? So I'm establishing that, hey, here's the first time we're producing this image. I need you to take my idea and make it. He responds back with that image. Is this to your liking? I respond, yes. And then we put a TM. Is it at the beginning of that cadence, or is it at the end of the cadence when you first start a TM?
It's actually a little different than that. It has to be a use in commerce. Which has its own technical legal meaning, but you have to be using it in a manner that identifies a good or service. So your back and forth communications with a graphic designer are not a trademark use. It's when you put that logo or catchphrase or slogan or image on a product and then you slap that on the internet and offer it for sale, that making it available to the commercial buying public is the first use in commerce. Well, I think our sound person is telling me that it's time to wrap up. I'm more than happy to chat with anybody afterwards. My usual going rate is about 1 beer per hour for
That's cheap.
for non-specific advice. So we didn't get to some of the things in here, but like I said, I'm more than happy to chat, answer questions, discuss things on an informal basis, and if you ever do need help, let me know. Let me close with one anecdote. Often the best way to, and this is purely practical advice, often the best way to get a lawyer to help you is ask a lawyer, who would you hire if you were in trouble? And not yourself. And that's always a good way to get a recommendation because I know other people in this line of work that are good that I would recommend, and I'll provide those recommendations too. So anyway, like I said, thank you all for your time, and I look forward to talking with some of you later.